Okay, thank you, Yev Barrios. Recent events in Armenia have alarmed many of us in the Armenian Bar Association. Armenia is where we come from, it is our hearts and our souls. We therefore have taken extraordinary measures to understand the domestic violence issues in Armenia, and now we take action. Our interest is to protect and make the Armenian family stronger by supporting robust domestic violence legislation in Armenia. We will fight to maintain and strengthen Armenian families and their autonomy. By doing this, we will in the long run strengthen Armenian intellect, ingenuity, and of course, the Armenian economy. Our panel today will discuss and compare domestic violence laws in the United States and in Armenia. I am Ruben Stepanian. I'm a divorce and family law attorney here in New York City. I am also an administrative law judge and an arbitrator. And now for our panelists. Hi, panelists. First, we have our Marina Manoukian. She is a family law attorney in Los Angeles, California, with 25 years of experience and an accomplished litigator in the domestic violence field. Hi, Marina. Next, we have Alfred Movsesyan, who practices family law in Los Angeles, California. After law school, Alfred served as a judicial law clerk in the family law department in Los Angeles County Superior Court. He worked closely with 5 family law judicial officers. Alfred is currently in private practice with the Boyajian Law, Inc. He is a tireless advocate fighting against domestic violence. Hi, Alfred.
Hi, Ruben.
Thank you for joining us. And next, we have Natali Diratsouian, who practices family law and matrimonial law here in New York and New Jersey. Prior to commencing her career in private practice, she was the law clerk with the Honorable Peter Manoukian. I hope I pronounced that correctly. The presiding judge of the family part of the Superior Court of New Jersey in Bergen County. She is a rising star named by the super lawyers in both New Jersey and New York. Hi, Natali. And least and certainly, and last and certainly not least, we have Ombudsman Tatoyan with us. Dr. Tatoyan is the human rights defender in the Republic of Armenia. Dr. Tatoyan is the head of the National Preventative Mechanism in Armenia. He is a member of the Council of European Committee for Preventing Torture. Previously, he has served as an international advisor to the Council of Europe. Good day, panelists, and welcome, Dr. Tatoyan.
Thank you very much, Mr. Stepanian, dear colleagues. And let me greet you and wish all of the success. And it is an honor to participate, to deliver a speech at the 31st annual meeting of the Armenian Bar Association. And from the very outset, I want to join the president of Nagorno-Karabakh, who expressed his wish to have the 32nd annual meeting of Armenian Bar Association in the Nagorno-Karabakh, Republic. I think this would be an excellent idea and another step to show our democratic Artsakh to the whole world. And before I start, let me first of all express my deepest appreciation to the Armenian Bar Association, and specifically, first I would start with Armenian Rights Watch Committee, Mr. Karo Ghazarian and Karnik Erkonyan, who protect Armenians' rights not only in Armenia, but in America, but all over the world. And I want to express especially also my thanks to Mr. Gerard Kasabian, Dusi Varpetian, Ms. Dusi Varpetian, Mr. Armen Hovanesyan, and Mr. Mesrop Kudagulia, because I had an experience and a great experience of cooperating with these very outstanding professionals, and I feel honored to be here and also to deliver this speech, to have this possibility. I will start my speech with words saying that highlighting the importance of women's rights protection, and I will focus today on women's rights protection, but in the light of domestic violence, of course, prevention. And Mr. Stepanian, as you very rightly said, the Human Rights Defender of Armenia is the national human rights institution in the country. It is the independent constitutional body vested with international A status, the highest status of accreditation provided by the UN Special International Group Commission. And as the Human Rights Defender, we have direct involvement and impact in fight against gender-based discrimination, prevention of domestic violence, promotion and protection of women's rights. To this end, emphasizing the fact that all the aspects of the work is of utmost importance. The crucial role of human rights promoting mechanisms and strategies should be pointed out distinctly. Let me here highlight the importance of protection, of course, of family values and our families. To my belief, families in Armenia and the institution of family lies at the core, at the heart of our society, and this is the basis of our strong society. But of course, with violence and with rights violations, we can't speak about strong families wherever, I mean, in any part of the world. And if to be more concrete, women all around the world definitely face discrimination that derives from stigma and stereotyping in regard to role of women in political and public life that impairs full realization of their political, social, economic, and other human rights, and hinders women's access to justice. Lack of women as decision makers and low level of participation of women in decision-making processes are also a result of largely accepted stereotypes, which leaves many voices unheard and causes absence of gender mainstreaming and gender sensitivity in many areas. Of equal concern are persistent vertical and horizontal gender segregation in the labor market, concentration of women in part-time work and low-paid jobs in the informal sector, low representation of women in management positions, etc. Stereotypes suppress potential of women, can cause and justify violence against women, and also distort development of society at large. Let me here say that as the Human Rights Defender of Armenia, we very largely focus on economic development of women and economic empowerment of women. And to this end, we have implemented certain projects at strengthening the economic empowerment of women, especially in regions of Armenia, because our studies show that one of the reasons of domestic violence is economic situation and the social situation of a certain family or of a certain woman. And let me also stress that for the purposes of domestic violence prevention, women's rights protection, as I said, we cooperate largely also with our international partners. So we have common projects with Council of Europe, with UNFPA, this is United Nations Fund for Population, USAID, EU, European Union, etc. And we also cooperate very largely with civil society, and I have to appreciate here the role of civil society in Armenia in this area. It is well established that one of the main means of fighting discrimination, as I said, generally, of course, is the economic independence. And we have started a special project which includes awareness raising on women's economic empowerment and activities conducted by women network organizations and assistance in creation of women resource centers in far regions of the country. To conduct the project meetings, we held in a number of small towns with local civil society organizations, women's rights activists, local authorities. The main goal of the project is to help women reveal their potential and to help organize an active group which then will be able to implement independent projects. Further, it is very important to apply innovative approaches. And we use the use of information technologies is very important, and it is widely used in our project. The Human Rights Defender has launched a campaign with the engagement of men and boys, as well as role models, public figures, sportsmen, and other influential persons, as well as inclusiveness and use of modern information technologies, such as social media, memes, public service announcements, and various announcement tools. Especially regions will be targeted through the campaign. This unique practice of using up-to-date technologies purpose is to target young generation and wide range of audience. It is worth stressing that all the means of the campaign are accessible for all persons. And by the way, the huge part of this campaign has already completed, and we are using also the latest achievements of technologies, especially for awareness-raising purposes. Mass media is a key actor in shaping the public discourse, and because they report on current events and provide a framework for their interpretation. And to this end, I want to bring one very important example. In cooperation with German embassy, some while ago, we could take a group of journalists for a special trip to Germany, where our colleagues journalists could study German experience, how to report cases on domestic violence and women's rights, so that not to have double victimization, and to provide the right knowledge to the society, which was another very important, let's say, this is one of our projects. To advise the parliament and government on measures to strengthen women's human rights apart from trainings of the state officers. By the way, we are very largely focused on training of state officials, because we, to our opinion, and I observed this during our monitoring, that stereotypes are not only in the society amongst just, people, but also within government officials, which creates another problem, another series of problems in tackling the issue of prevention of domestic violence. And we submitted several recommendations both to the government and to the parliament. And at the end, I wanted to focus also on a very important issue. We focus very much our attention on practice. The thing is that that violations in this area are hidden due to stigma issues, due to stereotypes, etc. Women prefer, or children, not to complain, and this is also something that is deeply rooted, I should say, within the society, especially if we are talking about regions of Armenia. And we had very recently one case which showed, this was one example showing the whole problems in the area. Like I will just I will be very short, and this is the last point of my presentation. A young woman of 20 years of age called at one point. We received a call on our hotline, and according to that hotline call, a woman of 20 years of age is illegally kept in one of the psychiatric institutions of Armenia. So, of course, we dispatched a rapid reaction group. The group went to the psychiatric hospital, and it was proved, and we revealed that this woman, this young lady, was being kept there illegally without grounds. So when we kind of tried to dig into this problem, and we revealed that a story that really shows the practical problems of that people may face, and even it may affect their destiny. This woman, we found out eventually that this woman was a victim of systematic domestic violence, physical violence, and verbal violence, I must say, from the side of her husband. So at one point, she decided to commit a suicide. She went to one of the bridges of Armenia, called very famous bridge called Tatoyan bridge, and she tried to commit a suicide from that bridge. All of a sudden, she changed her mind and she called the police. The police arrived, and the police took her to the police station. In the police station, they started they opened kind of an investigation, and all of a sudden when they learned that this woman wanted to commit a suicide from that bridge, with the reasons that are not that clear, for reasons that are not that clear, they called an emergency, ambulance service. The emergency arrived, and again, for that moment, no one knows why, they took her to the psychiatric institution after learning that she's kind of inclined to commit a suicide. At the psychiatric institution, the administration forced her kind of to sign some paper without disclosing the content of this paper. So this young lady, being shocked, by the fact that she is escorted by the police officers and she is already in a psychiatric institution, escorted then later by the ambulance. So she signed the paper. At the end, on the next day, it appeared that this paper was an agreement for medical treatment in a psychiatric institution. So when she learned that this was an agreement because they convinced her to sign it without disclosing the content, she started asking them, even begging, the psychiatric institution administration to let her go. But no one did this. And moreover, they started to treat her and to make certain injections without the agreement. So apparently this was illegal, of course. And when we arrived at the psychiatric institution, we learned that this woman is completely in her mind, and she was adult. So there were no signs of keeping her there, and the psychiatric institution was just requiring presence of her parents to come and take her. But their parents were not in Armenia at that time. So there was a real problem. And of course, at our request, at our requirement, let's say, they let the woman go. But the thing, because she was kept there apparently illegally. At my application, at my motion, a criminal case was launched at the investigative committee of Armenia, but because of the Armenian deficiencies of Armenian legislation, the case was dismissed later because the law itself has problems. Moreover, we had later a police officer who was responsible, who was tasked to kind of control her behavior. That police officer appeared to be a person who was calling her, like flirting and proposing to go and to have some drinks together, etc. So we have kind of this case showed, a bunch of problems, and this woman was not provided with any psychological assistance, with any need-based assessment, etc. And later, even we had to give some document, some paper to this woman to be protected from some members of the family, because the members of the family were like attacking her by saying that, and verbally, by saying that she's from psychiatric institution, then apparently, she's mad, she's crazy. So, and we had to provide, this woman asked a special paper from us that we certified that she does not have this kind of problems, but it was a result of illegally keeping her there. So this is one example that shows really lack of cooperation among institutions and problems also in the legislation. So here at this point I will stop. Sorry for my probably long speech, but I try to bring an example also to complete this with showing a concrete case. Thank you.
Yes, and Ombudsman, we do appreciate the real life example that it drew us in more. And I always like to say that, Armenia and Armenians all over the world are very special, but they are not special in this regard. Stigma as to domestic violence exists in the U.S. As it does all over the world. But let's just go on with our questions to the panelists. The first issue that we would like to address is, how is a domestic violence case initiated? And Marina, I'd ask you to answer that question.
Thank you, Ruben. So I think that today's goal is to compare the laws in the U.S. and procedures in U.S. To those currently in Armenia, so that we can better understand and we can better help develop better domestic violence laws in Armenia. So in California, I'm a California lawyer. I'll make this quick just so that everybody gets some framework as to how the system works in California. If law enforcement is involved, the police officers can reach out to a judicial officer and present a scenario where there is a present and imminent danger of harm to the victim of domestic violence and get an emergency protective order, which only lasts about 7 calendar days or 5 court days, whichever comes earlier. But after that, it is the victim that has to take affirmative action to get protection. And in California, you can go ex parte, which is basically no notice to the other side and no calendared hearing, to the court, present in writing your application for the protection that you want, which may include stay-away orders, property control, child custody questions, sometimes pet protection, and you can submit that in writing to the court. The court reviews it for a temporary restraining order purpose, where the person to be restrained does not have notice and opportunity to be heard. If the temporary restraining order is granted, then the victim can serve the restrained person, and a hearing is set for the permanent domestic violence restraining order. But a hearing in California is set regardless of whether the temporary protective order is issued. So once the ex parte happens, either the TRO is granted or it's not granted, a hearing is set. At that point, the person to be restrained is given notice and an opportunity to be heard. And then about 21 days later, they go in front of a judge, present exhibits and witnesses and testimony, and the judge makes the decision to grant a permanent restraining order or not, which in California can be somewhere from 1 year to 5 years, and it's also renewable after that. And it's important to note that in California, there are no filing fees for domestic violence restraining order applications, which makes it accessible to everyone who needs it. With that, I'll hand it back to you to compare it to other states.
Yes, and Natali, would you chime in, please?
Yeah, so the process is very similar to obtaining the process to obtaining a final restraining order in New Jersey is very similar as it is in California. The victim can make an ex parte temporary restraining order application, which means that the defendant or alleged abuser doesn't receive notice. And that can be done either at the courthouse or the police station. The victim can also request orders regarding custody, parenting time, support, stayaways from the marital home if the parties are living together, and the temporary restraining order can be granted. The hearing date is set, and the temporary restraining order is then served on the defendant, the alleged abuser. And then the temporary restraining order remains in effect until the final restraining order is granted at a hearing. The defendant must be served. And at the hearing, the defendant receives the opportunity to present witnesses, present evidence, cross-examine the victim or any other witnesses. If the final restraining order is granted, it remains in effect in perpetuity. So that's a big difference between New Jersey and California. New York is similar as well, except it's procedurally a little bit more nuanced because of the different court systems. The victim can go to the criminal court where the respondent is prosecuted by the state of New York by a district attorney for crimes committed against the victim, and that can lead to a criminal conviction against the respondent. It can also be done in the Supreme Court, where an order of protection can be issued in the context of a divorce case, and that's by way of a motion or an order to show cause that's brought. In the family court, which is the most common way to obtain an order of protection, a victim can fill out a family offense petition, and they're assisted by the clerk in filling out those forms. And just as in New Jersey and in California, they can also seek a stay away, exclusion from the home, temporary child support, and custody and visitation requests. And if the temporary order is issued, just as in New Jersey and California, you must serve the respondent with the summons and the order. And if the respondent agrees, the final order can be. If not, then the case proceeds to a hearing where the respondent is also permitted to present witnesses, evidence, and cross-examine the victim. If it's granted, the order of protection generally remains in effect for 2 years, and it can be 5 years if there are aggravating circumstances.
Okay, thank you, Natali. And I'd like to just point out that in New York, we do have the public prosecution, which happens in the criminal court, and the private prosecution, which happens in the family court or our civil court, which is called the Supreme Court here. And that's an important distinction, because if it is a public prosecution, then the witness, or then the victim who's incurred these abuses really doesn't, they have a choice of moving forward, but it's up to the public authority to prosecute, and it's not left to the victim, which oftentimes in a domestic violence situation, the victim doesn't really feel like they are the victim. They feel like, oh well, if I hadn't done this, then he wouldn't have done that, and we get into these justifications with the victim, and in a private setting, oftentimes the victim will pull out of her petition or her order to show cause. Now, Ombudsman, how are these issues?
Oh, Ruben, just to clarify, in California, there is also the criminal prosecution, which can result in a criminal protective order.
Right.
But to initiate a case civilly is what I was addressing. But in California, we have the same thing.
Yes. Ombudsman, how does Armenia deal with these issues?
Well, thank you, colleagues. It's really very interesting, especially in terms of further improvement of the Armenian legal framework. This is because this is pretty new. But according to our laws, there are protection measures for victims of violence within so they are called protection of measures within the family. So there are three types of measures: warning, decision for emergency intervention, and protective decision. So I should say that the protective emergency intervention order is it cannot last more than 20 days, and the protection measures, they cannot last more than 6 months, but it can be also prolonged. The thing is that we have also the possibility for having them during the criminal investigation. Another issue is that it has been an issue for a while whether private prosecution or public prosecution here should exist. And it has been, let's say, a debate not only in Armenia but other European countries as well. And finally, there is a landmark judgment of the European Court of Human Rights by which we are guided. And this is the case law is mandatory for Armenia. So according to this landmark judgment, this is famous judgment Opus versus Turkey. These cases, domestic violence cases, they are of public interest, and they cannot be dismissed if there is no application from the side of the victim, because this is another issue that we have this phenomena when law enforcement may convince the victim to take back the application in order to get rid of the case, so to say. But we have improved our legislation, and though the practice still continues, but I very much hope that we will get rid of this, let's say, problematic practice in the future. Just to keep it also very short, just wanted to say that during the criminal case investigation, it is possible, for example, if the perpetrator is not under detention, so the court still may apply or may keep the, for example, protection measures. And every measure that I listed has its own restraint measures. So if I'm not mistaken, we have a separate question. I will keep this response for that specific question to list what are the exact restraint measures for the perpetrator in Armenia.
Thank you. So let's move on. So the next question is, what happens once there is a restraining order in place in terms of the abuser? What are the ramifications in terms of the custody, parenting time, child support, and spousal support? And we'll take this question to Al.
Thank you, Ruben. As far as child custody is concerned, if in California Family Code, if an individual is found to have committed an act of abuse which meets the threshold requirement of domestic violence, there is a rebuttable presumption that an award of sole or joint custody to the perpetrator is detrimental to the child's best interest. The presumption may only be rebutted by a preponderance of the evidence. And to overcome the presumption, the court must find a couple of things. One, the court must find that it is in the best interest of the child for the perpetrator to have either sole or joint custody. And the court must also determine a number of factors, weigh a number of factors. One is whether the perpetrator has attended or needs to attend a better risk treatment program, whether the perpetrator has successfully completed a program of alcohol or drug abuse counseling if the court determines there's a need for that, whether the perpetrator has successfully completed a parenting class if there's a need for that, so, and a variety of other factors. So custodial time can certainly be negatively impacted by a finding that an individual has committed domestic violence. So if your time is impacted, you got less custody, child support is an issue as well, which can affect the amount of child support that the perpetrator has to pay. In general, the less time you spend with the child, the more child support you pay. It's a formula that the California courts use. It's a computer formula. As far as spousal support is concerned, the Family Code specifically provides that in awarding permanent spousal support, the court shall consider a number of factors, and whether a person has committed domestic violence is one of the factors that the court has to consider as far as whether any support should be paid or at what amount. And finally, I believe it was last year in 2019, the California legislature added a new section to the California Family Code, which provides that that any proceeding for a dissolution of marriage where there's a conviction for a violent sexual felony or domestic violence felony, and if the conviction took place within 5 years of the filing of the divorce, then the person that's been convicted, it's prohibited by law for the person to receive spousal support from the injured spouse. So there's huge ramifications if there's a finding of domestic violence in California.
Thank you. And Ombudsman, how are these issues handled in Armenia? And in your initial comments, you did mention the socio-economic factors, affecting victims. So please, if you can, kind of focus in on the financial aspects. I mean, as well as the custody, but I think the financial aspects are key here.
Well, yes, but if you allow me, since this is a very important provision, I would like just to mention, to make two updates. But the first is that the emergency intervention order is imposed in Armenia by a police officer. So consequently, the further control or supervision is conducted by the police officer, by the police. Then there is also a protection order, which is imposed by the judge, by the court. So, but the police still in charge of general, let's say, direct supervision of that measure. If to be just in terms of protection measures and of course the financial, the government has adopted certain rulings according to which victims are compensated. They are provided with certain amount of money, and there is also a possibility to move, or if there is no space to live, let's say, for the victim of domestic violence, then there are there is an institution of it is called, they are called shelters, and they are basically being operated by, they have been operated by NGOs, but the new law established a procedure according to which the government kind of is announcing a tender, and based on this, NGOs are operating also after the participating in this tenders, operating these shelters, and where women, let's say, or victims of domestic violence, let's put, which can be also women and children, can be placed. Let me bring a very small example. For example, for instance, when an emergency intervention order is imposed, the police or the court in the protection order may assign certain limitations. For instance, I will read out one or two. For instance, immediately and forcibly remove the perpetrator of violence within the family from the residence of the victim of violence within the family and prohibit his return until the deadline established in the law. If they live separately, prohibit the perpetrator of violence within the family to visit the workplace, etc. So these are the kind of limitations, and they are supervised, but of course we are monitoring as the human rights defender over their proper implementation. So far we experienced also problems, both
Ombudsman, I'm sorry if I may interject, but our committee so far has done extensive interviewing of people on the ground in Armenia, and our understanding is that in certain situations, the woman, the abused person, will be excluded from the home if the title belongs to the perpetrator or to the perpetrator's family. And it's interesting that you raised that point. However, our findings have shown that it's possible that the abused will be excluded from the home.
Yes, of course it's possible. So I was just reading out one of the, let's say, limitations. These are one of the options, let's say, or one of the requirements. But of course, there are cases when the victim has nowhere to live, let's say. And this is the most challenging thing. And I agree with you. Yeah, of course.
So what happens in those cases? My understanding is that the government is required to provide shelters for people. However, the shelters are scarce. In many parts of the country, there are no shelters. And in the highly populated areas, there are shelters, but not enough room for these victims to be, to stay. So how are we addressing those issues?
Well, with the shelters, there's really an open issue, let's say, with the shelters, and there is a huge room for improvement. One of the issues that is a matter of concern right now is the security of women in these shelters. So fortunately, we have really, let's say, good shelters that really do protect victims of domestic violence. But we had also cases when data is released to the police. So we are very closely monitoring, especially for this, to preserve the security of domestic violence cases from the side of an abuse of the perpetrator, because we have cases when the perpetrator continues continues not only this abuses or to find the women, but also for children abuse, etc., which is another issue. So this is also under our monitoring, and I agree with you that we still have these kind of issues, but I very much hope that these practical issues will be then later under the improvement. This is also connected pretty much to economic problems,
yes.
Not only lack of practice generally, the history of practice, but also economic problems.
Yes. Just for our viewers, I'm sorry, Marina. Just to note for our viewers, Armenia enacted its very first domestic violence law in 2007. So we are in the domestic violence and addressing domestic violence in its infancy stage, and Armenian Bar Association will partner with the Ombudsman, with many of the NGOs to aid Armenia in developing a much more robust legislation and also a system in place. Go ahead, Marina.
Just a small comment. The law was adopted in 2017, but this is a really very brand new law. And we still have issues with the more implementation.
Yes.
I wanted to mention that at least in California, and I'm confident in other states, the violation of a domestic violence restraining order may result in criminal prosecution. And I was wondering in Armenia, if there is a protective order and there is a violation, is there criminal prosecution or is it just a fine?
No, there is a criminal prosecution. There is a crime in the criminal code of Armenia for intentional, if the perpetrator intentionally is not fulfilling with all these requirements. Yeah, not only protection orders, but emergency intervention order and certain concrete limitations.
Okay. All right.
Thank you.
So let's move on to our next question. Who are the protected classes on the domestic violence laws? Marina, I'll go to you first.
Thank you. And again, this is basically compare and contrast. And I do believe that possibly the protected class in California is more expansive than that in the current Armenian laws. It covers obviously married persons or separated and divorced persons, people who were dating or are dating, engaged or used to be engaged, parents of a child together, in a dating relationship, or used to be in a dating relationship, and blood relations, adopted children, natural born children. And when you're filing for protection, you may include other persons to be protected in your application, even though there hasn't been a direct act of abuse against those, such as people that you live in the same house with. And sometimes in Armenian families, that's a bigger list because the families are beyond the immediate parents and children. They're grandparents or mother-in-law or father-in-law. So I do believe that in California, it's a bit more expansive than it is in the Armenian law.
So Alfred, do you have any to add?
I think Marina covered it all, actually.
Okay. All right, and Ombudsman, so who are the protected classes in Armenia? You're on mute, Ombudsman.
Yeah, okay. I hope you can hear me now. Yes. So, we have in the law, there is a specific provision that discloses who are the members of the family. So this is first of all the spouse, including the person in common marriage, former spouse, parent, including adopting parent, foster parent, a child, spouse of the adopting parent, parents of the spouse, and some other categories. Also, we have a grandmother, grandfather, sister, and brother, which are kind of included, including the half brother and half sister, of course, and sister-in-law, brother-in-law, and also son-in-law, daughter-in-law for the spouse's parents when sharing the same residence. So this is the scope of family, of a general notion of family, and the law then in later provisions, in further provisions, when describing concrete measures, they are only referring always to family or family members, and then just to get idea what is the law about, and you have to refer to the general provisions that I just listed.
Okay, thank you, Ombudsman. So, in our experience here in the U.S. and our understanding is that in Armenia, intimate partners are not covered, or is not a protected class. Is that true? And what's your point of view on that issue?
Well, the family is just I just described. This was the let's say exhaustive list.
Okay, all right. Okay, let's move on to our next question. What is your experience with the cultural norms and the stigma associated with domestic violence, Marina?
I think that I hope the experience that we have in the United States may be provide some hope to those in Armenia. I have been doing this for 25 years, and I have to say that I have seen a change in the stigma. It's never going to go away entirely, but I do believe that, especially in the Armenian community in California, when the victims see that the process works, that they can get protection and they can get themselves out of a life of abuse, the stigma over time in the community becomes less because they see that the laws work to protect them. I think that if victims feel that if they speak out, things are going to get worse, or that the law or law enforcement is not there to protect them, obviously they're not going to speak out, and the price that they pay is airing their dirty laundry. But given the cost benefit analysis of a life of abuse, airing your dirty laundry, but then getting yourself and your children out of an abusive home, if the system works, I think over time the stigma will be less. I don't think it'll go away, but that's been my experience in California for the last 25 years.
Right, and Ombudsman, you addressed this issue in your opening statement, but would you like to elaborate?
Yes, of course. This is really very important issue, and I would say that this is probably one of the main basic reasons that really hinders the process of prevention of violence. So first of all, of course, women, children, but basically women and the children as well. They really they're not that willing, to complain or to raise their issue. They rather may prefer, not to raise it because of certain reasons, as Ms. Manoukian very rightly mentioned. For example, if they know that there will be no investigation, and we had one case when the law enforcement authorities not only convinced her to take back the application, but then they sent back her, within the same day to the perpetrator, the person who was committing the violence. So this shows also that this stigma and stereotypes we have to eradicate also from the officials, law enforcement. By the way, I have to say that the police here in Armenia, at the central office, we have a department, and I have to say that my office, including we cooperate with NGOs, but with this police, I want to focus on the police at this very specific point. With this central department, we have really very good cooperation. So they're very open, they're very cooperative with us, and they're very responsive when we submit, and they do try to change things, but the problem is very deeply rooted, and it has a systemic issue. It is a systemic issue. And for example, if you go to regions, to other remote areas, then you see the questions there, you have more. And apparently one of our huge problems is the investigation. So they're connected to the investigation, not only police, but investigation authorities generally. We have also problems, of course, not with the social authorities, social security authorities, and local self-government authorities. Look, when we are talking about children, very recently in Armenia, in Tavush region, there was a really very tragic case when, as a result of domestic violence, a child then, died in the hospital. This is a really very tragic and I would say very stressful case for the whole society. But was yet another, signal for the society that we have to be active in this area, to join all our efforts to combat this stigma and, stereotypes, so that people do not hide their problems, but they do raise. But for this purpose, we have to have established system of governance in the country in this sense, so that people are confident that they will get protection. For instance, there is a system of bodies in Armenia called trusteeship and guardianship authorities. These are the most unestablished, problematic authorities in Armenia. They are almost, if I say that there is a lack of professionalism, it would be, too mild for them. This is, these problems, the problem is that they not only do not protect rights of children, but they do violate them. And and the whole my office, my responsible staff, and we sometimes, not sometimes, very often, we get so angry on them that these people, how can they treat, the lack of capacity, etc. So to this point, yeah, I fully agree with you, and this is, it may have, this improvement of the situation will have, we have to improve it, and a very important thing is to conduct large-scale awareness-raising programs. This is the problem. As the human rights defender, I did it. But we are one institution. We can't cover the whole country, all institutions. It should be very wide scale and awareness raising, working with media, social media, is very crucial. So because stereotype, what is to my opinion, stereotypes, basically this is because of lack of knowledge. People don't know what to do, how to protect themselves, and that is why I consider it crucial to have this large scale awareness raising, not only in the society, but also among government authorities.
Right. Okay, thank you, Osman, and thank you, panelists. So the Armenian Bar Association, we have just begun the work on this issue. This is a call out to every viewer, participant in the CLE. If you are an attorney, if you are a social worker, therapist, counselor that is involved in this field, we want you to come and join us. We need you to come and join us. We want to develop a strong strategy, and we want to partner with the Ombudsman's office and the NGOs out in Armenia to make a change. Not just to talk that we're going to make the change, but to actually make the change. Thank you, everybody, and back to Gito and Lucy.